All right, having a couple little technical issues there, so thank you guys for bearing with us. Good afternoon, and thank you all for joining us for today's month of service presentation of wrongful termination. My name is Nia Murray. I am Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the month of service collaboration. Also included is the City of Houston's Department of Neighborhoods, and joining us today is Ms. Myra Hippolyte. Also, our presenting partners today on behalf of Houston Bar Association, we're being joined today by Ms. Michelle Miller and Mr. Eric Cassidy. Also included in the partnership is Lone Star Legal Aid, the Earl Carl Institute, Houston Volunteer Lawyers, Harris County Appraisal District, and Harris County Tax Assessor Collector's Office. We know that's a lot of people to try to name all at one time, but we want to make sure we do at least acknowledge all of our partners there. So, but basically what a month of service is, it's a collaboration of these 8 different organizations that come together on a monthly basis to offer a variety of workshops to the communities that we all serve relative to asset building, asset protection, maintaining of generational wealth, and community empowerment. And included in that series of workshops are a variety of different legal workshops that volunteer attorneys present to provide information to the community about resources or information that they just so happen to not even know about. Myra and I learned every single month of something new because we are not the experts. By no means do we ever pretend to be the experts, which is why we bring those experts to you directly so that you can get this firsthand information for free, by the way. So in addition to that, there's quite a few other workshops that we offer on a monthly basis, and I'll go over a few more of those at the end of the presentation. But I want to say that the legal workshops, when we present these, that the information is for educational purposes only. It is not legal advice. However, we do encourage you that if you find yourself in need of any civil legal assistance, that we encourage you to reach out to our legal service partners for more one-on-one assistance. We try to get you guys to be as interactive as you'd like to possibly be, ask whatever questions that you may have, but we are streaming live on our social media platform as well as having this session recorded. So we want you to be mindful of that, and we try to protect your privacy as much as possible. So when you're asking your questions, we ask that you try to keep them as general as you possibly can without having detailed personal information kind of getting out there for everybody to have access to. So we are having someone, they're going to be monitoring the chat, but we will have questions and answers at the end of the presentation. So feel free to type your questions into the chat, or wait until the end and raise your hand, and you can unmute yourself, and you can ask the questions directly of the presenters. For those that are following us on Facebook, feel free to type your questions into the comment section, and we can read your question at the end of the presentation as well. So with that being said, we'd like to thank you guys for joining us again for another month of service presentation. Also, I want to kind of remind everybody, attorneys that do join participate in the month of service workshops, in the legal service workshops. Whenever you see that course number there, the Houston Bar Association is sponsoring free continuing legal education credits for those attorneys that do join, so, or that do participate and watch the presentation. So just look for those course numbers for, take advantage of this free CLE class. We know those things cost. So with that being said, I'd like to introduce our partners and our presenters, and we will move right on into our presentation. So Ms. Myra.
Thank you, Ms. Nia. Welcome, Ms. Michelle and Mr. Eric, to the month of service collaboration partnership. It's one of those days, so just bear with me today. I attended 2 meetings, running from one meeting to another, so bear with me today. Again, my name is Myra Hippolyte. I work with the City of Houston Department of Neighborhoods under the direction of our new division manager, Paul Green. Our new division is called Office of Neighborhood Engagement. And on behalf of Mayor Sylvester Turner and our director, Takasha Francis, we want to welcome you to the Month of Service program. The Month of Service program is all about that, giving you back free information so that when you're ever going through whatever stressor in your life, you can make the right decision. I know we always, kind of have a little a situation when something happens and we're going like, well, okay, my house just burned. What's the first step I need to do? Just like COVID. Okay, I've got COVID. What do I need to do with my generational wealth? Who do I transfer it to? Or gosh, I lost my job. Was it legal or not? Well, that's what we're going to have a class on today, a virtual workshop. All the information is all about educating you. Everyone, I don't care who you are. We come to find out we have people from England, we have people from Puerto Rico, we have people from Cuba even. We have someone from California, different cities throughout Texas attending, watching our virtual workshops. So know that it's not only about issues happening here in Houston, Harris County, it's happening everywhere. And so we just want to make sure that you have the right information, that you're not stressed, and we're here with you. And yes, we are walking right by your side, but we are not holding your hand. And by that is that we're walking right by your side by giving you the information, but it takes you to come into the virtual workshops and get educated. Thanks, everyone, and have a great day, and you're going to enjoy this presentation. Thanks.
All right, thank you. Let's see, Eric, would you like to go first? And then Michelle can introduce herself, and then she can go on into her presentation after that.
Sounds great. And thank you for having me here. I'm very excited. My name is Eric Cassidy. I'm an attorney in Texas. I've been practicing for about 20 years. And I'm with a firm that's called Curtis, Smalley, Prevost, Colton, Mosley. We generally just go by Curtis. My background in employment law I'll get into when I do my speech, but I'm very excited. And actually, I'm very excited to hear Michelle as well. So Michelle.
Hi, thank you so much for having us, both of you, Myra and Mia. Everybody's been so polite and so helpful. Eric and I have been looking forward to this for a long time, and we're happy to be able to share what we know. There's a lot of information about wrongful termination that there's a lot of misconceptions out there that we want to clear up. That's the most important thing. And Texas laws are a little funny, so that shouldn't surprise anybody, but we're going to get into those, and we're going to make sure everybody understands what a wrongful termination means, what it looks like in Texas, and hopefully answer a lot of your questions about employment law. So we're just real happy to be here.
Okay, great. Go right ahead, Michelle.
All right, well, let me just jump on in. Let me share my screen here. Okay, so both Eric and I were invited here from the Houston Bar Association. We're both members. I am a 17-year practicing attorney. I work at a law firm called Jackson Walker, and I'm senior counsel there. I have been practicing employment law the majority of my career, 17 years or so, but I was a prosecutor in Harris County for a couple of years. So I've got a pretty varied background, a lot of trial experience. Employment law involves a lot of trial. So that's primarily what I do. I'm board certified by the Texas Board of Legal Specialization in Labor and Employment Law. So that is pretty much my specialty. And I'm even allowed to say that I'm specialized. So that's what I do, and it's what I've always loved to do. So questions and things like that are always going to be encouraged. One of the things I love to do most of all is to explain the laws in Texas, because it's so important for people to understand that there is no such thing as a wrongful termination law in Texas. Now, if you were in California, that would be a whole different ballgame. But in Texas, no such thing. So if you feel as if your termination is unfair, if you feel like it is unethical, if you feel like it is immoral, while that might be the case, it doesn't mean it's illegal. There is just a very, very narrow reasons for you to even claim that you were wrongfully terminated in Texas. And we're going to go through some of those. But just the main takeaway that I want everybody to have is there's no law out there. There's no statute. There's no regulation that says, excuse me, that it is that there is such a thing as wrongful termination in Texas. So that's number one thing. And the reason that there's no wrongful termination in Texas is what we call an employment at will state. Now, this applies to all phases of the employment relationship: hiring, firing, terminations, layoffs. It applies to if you're going to get promoted or demoted. The employment at will applies to all of that. And what that says, now that is a specific law here in Texas, it says that absent a statute, which is a law, or an express agreement, such as you have you have an actual written employment agreement, either party, and that is either the employee or the employer, can change the terms or conditions of employment, which means you can terminate the employment, the employee can terminate the employment, the employer can terminate for any reason or no reason at all without advance notice. Now, this is the most important thing I want you all to take away here. Basically, what that means is as long as there's no statute which prohibits it, and as long as there's no employment agreement, written employment agreement, then you can be terminated for any reason or no reason at all. An employer can terminate you if they don't like the color of your shirt, and that is not illegal. Now, that's Texas law. It's different in California, but I'm only going to talk about Texas law today. So that's the most important thing. If you take away nothing else, I want you to take away that. It is not illegal to terminate a person. It is not illegal to quit. And the Texas legislatures kind of feel like, well, you know, if you can quit for any reason at all, then an employer should be able to terminate you for any reason at all. And that's employment at will. So, you know, as I said before, if you feel like your termination is not is unfair or is unethical or immoral, while there are a few places that we can get around, typically it's not going to be illegal. So, for example, there's some laws that you have to think about as laws, and there are things you have to think about just as policies and manuals and things like that. A lot of people think that if you have an employment manual and it has a 3 strikes you're out rule, you can still be immediately terminated, and that is true, but it's not illegal. Employment manuals are not laws. Anything in that employment manual, if your employer violates it, if they, like I said, if they have a 3 strikes rule and they fire you on the spot, you can't go to court and say, but it's in the manual, because that's not a law. It's not a written law signed by the legislatures and enacted by the Texas Congress. So that's what I want you to take away. A few other things, there's no law which requires you to give 2 weeks notice. You can just quit if you want to, if you need to. That's not illegal. There's no law that requires you to give any kind of notice before you're terminated or before you quit. So, as I said, it goes both ways. An employer doesn't have to give you notice. They can terminate you for any reason. Same goes to employees. You've got sort of the same rights. Now, there are some protections that we need to talk about, and that's kind of what I want to move into next. But just to make it clear, none of these things are illegal. Now, I get a lot, and I'm bringing this up because I get a lot of potential clients who come to me and say, well, they changed a personnel policy without telling us. They changed pay. They changed my pay. They changed my title. They transferred me. Unless it's in a written employment agreement, not illegal. They can do all of this stuff. Now, there are some exceptions to the employment at will doctrine. And the employment at will doctrine, remember, it says absent a statute or an express agreement. So here are some statutes which are, these are going to be the things that are going to be sort of labeled wrongful termination. We don't call them wrongful termination. We call them, depending on what it is going to be what the scenario is going to be. Typically, it's going to be an adverse employment action, because in these laws that we're going to talk about, for instance, in Title VII or in the Texas Commission on Human Rights Act, there are discrimination claims that an employee can bring against their employer. But the discrimination doesn't necessarily have to be for a termination. It can be for a demotion. It can be for a change of pay. It can be for all of these things, but those are called adverse employment actions. So it's not just necessarily wrongful termination. So that's something you've got to keep in mind too. But here are some of the exceptions. Title VII, this is Title VII of the Civil Rights Act of 1964, and it was enacted to protect it was enacted to protect Americans from discrimination based on race, sex, religion, I'm sorry, race, sex, religion, national origin, or color. And it's kind of unusual because we've got the Title VII statutes, and then we've got the Americans with Disabilities Act, and then the Age Discrimination in Employment Act. And why that's a little unusual is because Texas has its own discrimination claims that you can bring against your employer. But all of these are sort of wrapped up in one TCHRA. So within all of these, you're going to get your discrimination claims against your employer, which you can bring for discrimination based on age, race, sex, sexual orientation, transgender status, national origin, color. So all of these are going to be enacted in Texas. So these, if your employer terminates you based on a disability, based on your age, if you're over the age of 40, based on your sexual orientation, based on your sex, race, age, color, or religion, then those are considered wrongful termination. So those are some of the exceptions. Some other exceptions to the wrongful termination are workers' compensation retaliation. And we're going to talk about all these in a little bit more detail, but I just want to kind of give you an overview right now. Workers' compensation retaliation says that you can't be terminated for filing a workers' compensation claim, for initiating a workers' compensation claim, and there's some other things in there. So that's another statutory exception to the employment at will doctrine. OSHA. OSHA is a federal law, and it's hard to talk about the exceptions within OSHA because there are about 20, I think, federal statutes, and each statute has its own exception. So we'll go over those, but retaliation or termination for filing an OSHA claim is another way you can get around the employment at will doctrine in Texas. USERRA. USERRA protects military personnel. And again, we're going to go over these in detail, but those are some of the, that's a law that protects military personnel from if they are deployed or if they're returning from deployment, they have to be reemployed. And if they're not, they could bring a claim against their employer. And that's another exception to the employment at will doctrine. Jury service, you can't be terminated for taking part in jury service. If you do, that's considered a wrongful termination. And I always hesitate to say wrongful termination because I don't want anyone to think that is a law in Texas. So that's just the lawyer in me talking. But you cannot be discharged for jury service. If you are, that is an adverse employment action. Child support withholding orders. If you have child support withholding and you are being forced to pay that and you're terminated for that or not hired, that could also be an adverse employment action. Compliance with a subpoena, same thing. If you're forced to comply with a subpoena and you're terminated or you are demoted or something like that, some kind of adverse employment action, then that is also going to be an exception. So as you can see, there are several exceptions to the wrongful termination. We just can't call it wrongful termination. Okay, here's another one, public policy exception. And this is important because what it says is you can't be terminated or have an adverse employment action if you are if you have refused to commit a criminal act for your employer. Now, it's a little tricky because it has to be an actual criminal act. There has to be a statute on the criminal act, and it has to be actually enforceable. So you can't say, I think that was fraud. And my employer wanted me to commit fraud. You have to say, my employer wanted me to commit fraud under such and such a criminal statute under the Texas Penal Code or something like that. And then there are lots and lots of whistleblowers, whistleblower statutes. We're not going to go over all of them, but we'll go over a few of them just so you kind of get a feel for what kind of claim you could bring against your employer if you were considering yourself wrongfully terminated. So discrimination, and again, I'm just going to kind of buzz over these because I think it's important for you to understand. Discrimination in and of itself is a law that is governed by the Equal Employment Opportunity Commission. And that's a federal administration. Texas has its own state administrative body, which is sort of a co-administrator of those laws and in the TCHRA. But in general, what they say is that, again, you can't be discriminated against by your employer. And if you are discriminated against for one of these protected classes, so the protected classes are what we've discussed: race, sex, sexual orientation, transgender status, religion, color, national origin, race, disabilities, or age. And that only protects employees over the age of 40. If you are, and then the Texas Commission on Civil Rights Act encompasses all of these. If you are terminated and you believe you were terminated because of your race, then that is what I would consider a wrongful termination, and you could bring a claim against your employer for that. So that is one of the biggest statutory exceptions to the employment at will doctrine. Now, retaliation is important to understand as far as wrongful termination goes, because if you are, if you take part in the Equal Employment Opportunity process, if you head on down to the TWC or the EEOC and you file a charge of discrimination, or if you assist someone in filing a charge, or if you bring a claim to your company, to your HR, to your manager about a possible discrimination situation, either involving you or another employee, and that employee is terminated, or you are terminated, or you suffer some material adverse action, and it doesn't even have to be a termination. It could be a demotion. It could be a difference in pay. They could send you, to the worst facility to work at, and you can prove that there's a causal connection between your race and that material adverse action, then that's considered retaliation. And all of these laws under Title VII, the Americans with Disabilities Act, the Age Discrimination in Employment, all of these have retaliation elements to them. So that is another statutory exception to the employment at will doctrine. So you can bring a claim of retaliation against your employer. And that is what we also consider wrongful termination. Okay, so quickly, I want to just very, very quickly go over how the EEOC or the TWC works in case you are wrongfully terminated. In case you know of somebody who's been wrongfully terminated, or in case you feel like you have helped somebody and you might have been retaliated against. So essentially, if you're bringing in an employment discrimination claim against your employer under Title VII or under, excuse me, under the TCHRA, the Texas Commission on Human Rights Act, you cannot just go and walk into a courtroom and file a lawsuit against that employer. You must go and file a claim. It's called a charge of discrimination with either the EEOC, or which is the Equal Employment Opportunity Commission, or the Texas Workforce Commission. You must do that first before you file a lawsuit against your employer. Now in Texas, we're a dual filed state. So if you head into the TWC or you head into the EEOC, typically they're going to dual file it, which means it's going to be filed with both agencies. Both agencies, I would recommend if you do go ahead and do this, I always recommend filing it with the EEOC first, only because they always dual file with the TWC. And the TWC, if you file it by themselves, they may not file it with the EEOC. And you want to file it with both because then you get your choice of court. And it matters whether or not you're going to be in federal or state court, and your attorney is going to handle that, but try to get it dual filed if you do. So you file your charge, you say, I've been discriminated because of my race. Your case is assigned to an investigator. The investigator will require the employer to file what's called a position statement. They're going to offer you mediation. And then if you don't want to mediate, hopefully if you mediate, then everybody resolves the case. There's usually a monetary settlement, and you go about your way, and everybody ends up with the matter resolved. If not, then evidence is gathered, and that can be witnesses could be interviewed, facilities could be investigated. The investigator does a very thorough investigation, and then the EEOC and the TWC they're either going to take on the case themselves, which is very, very, very rare. I think it happens in 3 or 4% of the cases. Or they're going to issue you a notice of right to sue. You're going to take that and you're going to head on down to the courthouse, and then you can file a lawsuit against your employer for wrongful termination. Can't do it without following these steps if it's a discrimination claim. So that is kind of how that works in the discrimination world. Keep in mind that there are deadlines for you to file these, and they're somewhat short. The EEOC is less than a year after the adverse action. So if you've been terminated and you think it's a wrongful termination because you were terminated based on your race, then you only have 300 days to file a charge of discrimination with the EEOC. With TWC, it's even shorter. It's 180 days. And then when you get that right to sue letter, you only have 90 days in the EEOC to file a lawsuit. Again, a lot of attorneys would prefer to do it this way because you end up in federal court, which is much more, it's just a little bit more efficient, and the attorneys are a little bit more the judges are more learned when it comes to discrimination claims and Title VII. But if not, the TWC is the state courts are just as good, and you have 2 years to file your lawsuit if you file it with the TWC. So these are very, very different deadlines, but just to keep in mind, there are deadlines if you are going to bring a wrongful termination claim against your employer. Let's talk just a little bit now about a few other, I'm just going to quickly kind of go through some of the other statutory exceptions to wrongful termination and ways to get around the employment at will doctrine. One of the most important ones is workers' compensation retaliation. And what this means is that it happens if you were discharged or discriminated against in any way. And that could be you were demoted, you were transferred to the worst facility, you aren't working, now you're working the night shift, where before you were working the day shift. Those kinds of adverse employment actions. And these happen because you either filed a workers' compensation claim in good faith. Now, that doesn't mean it went through. It doesn't mean that the TWC accepted it. You just filed it and you had a good faith belief that you were entitled to workers' comp. And if you did that, or if you hired a lawyer to represent you in such a claim, or you instituted or caused a proceeding to be instituted, to get started, or even if you testified or you're about to testify in a workers' comp hearing, all of those are considered protected activities. And if you take part in any of those and you were discharged or discriminated against, then that could be unlawful for your employer. And that could also be a another exception to the employment at will doctrine. So workers' comp retaliation is another way that you can possibly bring a wrongful termination claim against your employer. Now, it has to be subscribing employers only. So it has to be an employer who actually carries workers' comp insurance. There's a 2-year statute of limitations, and you can do this. You just head right down to the courthouse. You don't need to go through the TWC or any kind of administrative body. You just head on down, file a lawsuit. So there's another exception. Whistleblowers, there are, I wouldn't say a lot, but there are several different whistleblower laws which you could invoke to bring a wrongful termination claim against your employer. The most prominent one is what's called the Texas Whistleblowers Act. And what this means is if you are a public employee, this is often invoked by police officers, city government employees. If you have reported illegal, it should be illegal. Let me go down here. Illegal or ethical violations, legal or ethical violations by your employer. So for instance, if you're a police officer and you have reported unethical or illegal activities to the appropriate law enforcement agency, then there is an adverse employment action filed against you, or not filed against you, but taken against you, then you could bring a claim under the Texas Whistleblowers Act. And that's another exception to the employment at will doctrine. Now, this one's a little tricky because it has to be, you can't just say my employer, told me that. So for a police officer, this is just a hypothetical. If a police officer goes to his senior officer and says, "Hey, my captain just asked me to, write down the wrong number of a license plate so that he could get somebody in trouble." That's not reporting it. It could be reporting it to an appropriate law enforcement agency, but the act is kind of a stickler about how it goes about being reported. So you have to follow all of the rules in that act in order to actually bring a claim against a public employer, and it's not easy, I could tell you, to fight the government. So that's something that really an attorney can guide you on. But it is there, and if you are a public employee, that's something that is there to protect you. Physicians and nurses are protected by several different statutes which protect them. For instance, there's if they are employees of a hospital or a mental health facility, some kind of treatment facility, and they can't be discharged or discriminated against for reporting a violation of the law. And that's another exception to the employment at will doctrine. And in that one, they can either report it internally or to a supervisor or to a state regulatory agency. The way that it is reported is a little bit different than the Texas Whistleblower Act, but know that there are those protections for physicians and nurses and some healthcare workers for reporting acts, if they're reporting violations of the law. Hazardous chemical workers is another exception to the employment at will doctrine. And what it says is an employee may not be discharged or discriminated against in retaliation for filing a complaint, assisting an inspector, instituting a proceeding, testifying, or exercising a right under the Hazard Communication Act. So that's a very specific act, but it does protect employees if they are reporting violations of federal laws as far as hazardous chemicals go. So those are the kind of whistleblower acts, and there are a few more out there. We can't talk about every single one, but those are the main ones, and it's important to understand that there are these exceptions to the employment at will doctrine in Texas. One of the other one is USERRA, and USERRA it is for service people, either a past or present member of the uniformed service. If they've applied for uniformed service or you're obligated, to serve in the uniformed service. An employer cannot deny that service member or past service member employment, reemployment, retention in employment, promotion, or any benefit of employment because of that status. That's a really important one now because there's still a lot of military service people out there, and their employers must rehire them when they get back from service, as long as, and I always have to make sure that people understand that there's a lot of hoops you have to jump through. That the service people, before they leave for service, they have to make sure that they give their, for instance, they give their employer advance notice. I mean, you usually have to give them your papers and let them see them. You know, there's some other, I won't go through all of these, but there are some hoops that service members have to go through. And if they go through everything and they do everything right and they're not reemployed, then that again is a wrongful termination claim. That's an exception to the employment at will doctrine, the USERRA, that you can always try to use if you are a service member not reemployed. It's called the Uniformed Services Employment Act and Uniformed Services Employment and Reemployment Act. There's also a health insurance protection provision in there. It doesn't really have much to do with wrongful termination, but just know, I think it's really important for employees to know that they have these rights. Even though it's an employment at will state, you are protected. For instance, the same with the Family Medical Leave Act, which it says if you filed a charge, instituted or caused to be instituted any proceeding under or related to the Family Medical Leave Act, or if you've testified or about to testify in an inquiry, it kind of reads the same way as the workers' compensation claim, or if you've given or about to give information, you cannot be discriminated against. You cannot be discharged. So if you have taken FMLA leave, if you're about to take FMLA leave, if you've come back from FMLA leave and been discharged, you could be able to bring a claim against your employer as an exception to the employment at will doctrine. Now, this is only for private sector employers who employ 50 or more people in 20 or more work weeks. And it's also for public agencies. So there's some limitations there, but that's another exception to the employment at will doctrine. OSHA, I was preparing this presentation and you know, I hadn't looked at some of the exceptions before, and I remembered that there are about 20 or so federal laws, and each one of them has their own retaliation, separate retaliation provision in them. So for instance, the Safe Drinking Water Act might have a provision that says you can't bring an employee who brings a claim against their employer for violations or reporting under the Safe Drinking Water Act has 30 days to file a claim, and this is an exception to the employment at will doctrine, something like that. That's not exactly what it says, but something like that. But each claim under OSHA, under the Occupational Safety Hazard Act, has its own retaliation claim under it. So we can't go into many of these, but they're right here. And all you have to do, honestly, is just Google Department of Labor OSHA retaliation, and they will pop up. They have these wonderful publications that you can look at. And if you are, if your job is subject to any of those federal laws, for instance, Solid Waste Disposal Act, Toxic Substances Control Act, as we talked about, the Hazardous Chemical Act, there are almost always going to be exceptions in there for retaliation and for employees to bring employers. One of the issues with bringing a claim under OSHA, though, is they have very, very short limitations period. Most of them you have to bring a claim within 30 days after the alleged violation. So they're very, very quick. Honestly, I've only handled 2 or 3 in my career because no one ever comes to me in time. So you've got to really kind of jump on those. Jury duty, that's another one. You can't be discharged. Your employer can't threaten to discharge you. You can't be intimidated or coerce a permanent employee because the employee serves as a juror. You You are not allowed to really, they can't do anything to interfere with your jury service. And that is an exception to the employment at will doctrine. But outside of the wrongful termination realm, I just want to mention the employees don't have to be paid for jury duty. It's not required that they pay you. Time on jury duty doesn't count towards overtime. And employers can require you to use vacation or other paid leave time. So those are just what I call little lanyards. They're a little extra information. Don't have to do with wrongful termination, but understand that all of these laws that affect your employment affect you in some way. So it's really important to keep these all in mind. Same thing with voting. Employers, they can't refuse to provide you time off. But the key with voting is an employee must be given paid time off to vote only if the polls close within 2 consecutive hours outside of the voters' working hours. So if I work until 7 o'clock and the voting booths, they close at 8 o'clock, then I have to be let off at least 6 or so to get there to be in time to vote. So it's that 2-hour period that the employers have to be mindful of under the law. You know, and in that one, in this law, you must be paid time off to vote if the polls close within those 2 hours. So that's the most important thing to keep in mind. It is a felony to retaliate against an employee who voted for or against a particular candidate or a measure, or if you refuse to reveal how he or she voted. So, you know, not only are there protections for being able to vote, but your employer could be subject to a felony if they're doing any kind of coercive measures about how you vote. We like our freedom to vote in the United States. And I think this is kind of the last thing I want to talk about: breach of an employment contract. I write a lot of employment contracts for a living. Typically, they are going to be for executives, people in management, technical people, and things like that. And breach of an employment contract is going to act just like just like a contract, just like as if someone had breached a contract to build a roof on your house. You've got to have a valid contract. The employee has to perform. The employer breached the contract and the employee was damaged. It's all just like an employee contract. It is very, very, very hard to prove any kind of a breach of an employment contract without a written contract. Offer letters are not considered employment contracts. Employment manuals, policies, not contracts. So just keep those things in mind. And I think that's it. I think I'm going to stop talking, and I'll let me get out of here, and I'll let Eric Cassidy take it over from there.
Great. Well, thank you very much, Michelle. And I just want to say that that's an absolutely excellent overview of all the various discrimination statutes. And because I knew, of course, that Michelle was going to cover this ground, I thought I would take a slightly different approach and maybe give some really practical considerations about when you're claiming discrimination, or if you're an employer, when you're fighting a claim of discrimination, or also allegations under the Family Medical Leave Act. What are some of the things you need to think about? Before I do that, I wanted to touch on, and also I want to thank, you can't see her on the line right now, but my executive paralegal, Heather Martinez, is here, and she'll be helping us with the PowerPoint presentation. And Heather, if you don't mind, go ahead and put it up on the screen. My background is a little bit different than Michelle's. Michelle is highly trained and professional and certified in this area. I came out of law school at University of Texas about 10, 20 years ago, and I was focusing on what we'd call commercial litigation or white collar, for instance, criminal acts. And I was a trial lawyer. So what that meant is I would become involved in these various government investigations. And that is how I really ended up starting to work more and more in the employment law context, because you will have companies investigated by government agencies under various statutes. And then outside of the investigation context, I really got involved because of employment contracts. As Michelle said a little while ago, there can be claims based on a written private contract between an employer and an employee. One of the most common kind of claims is a theft of trade secret or theft of a breach of covenant not to compete. And those kind of claims were extremely popular. They still are, but they're very popular about 5 years ago. So as a trial lawyer, I was being pulled into court and kind of learning about this from the level of either pursuing, prosecuting, or defending. So that is kind of my background. And I wanted to mention one other thing, and that's I also came at this from a slightly international perspective. My traditional work that I've done when it came to advising clients of the various statutes that Michelle has gone over was really for international companies. My firm has that kind of reputation. And so just being able to explain what she did so elegantly to people who are not familiar with the various statutes and laws in the United States has been part of what I do as an attorney. Now, can everyone see the PowerPoint? Do we have it up, or do I need to take a second here to get it up?
It's not up just yet.
Okay. Heather, can you try and put it up? As she does that, I want to take a slightly broader view. It's not just the statutes that someone has to be very familiar with when it comes to discrimination. And to really understand those statutes, you need a trained professional like Michelle to walk you through it. But in addition to that, it's very important for both HR professionals, company owners and supervisors, and even employees to understand the kind of facts or conduct that is going to come and be in the forefront of whatever claim you make. As I said, I'm talking about the practical considerations in employment law. And Heather, if you could go to the next slide, I want to briefly talk about government investigations. And go ahead and go to the next slide as well. Just very basically, when you start talking about federal government investigations, and Michelle touched on state of Texas primarily, but I know she does both. From a company's point of view, the standard defense strategy, when they're being investigated by the government for some kind of violation of a statute, is to do what they call the Yates Memorandum Defense. And that is a company will typically identify the individuals within the company that they feel are the rogue actors. They'll identify those individuals to the government, and they'll participate, if not conduct, their own investigation with the aim of giving that information over to the government to aid them in their investigation of the company. That allows the company to get a certain amount of credit for its cooperation in a government investigation. Now, I mentioned that for several reasons. One, if you're the HR professional or outside counsel or even the company, it's typical for them to identify the individuals, blame those individuals, ultimately terminate them, and work with the government to cooperate. If they do that, then any penalties they may face are typically minimal. That raises point number 4 on this specific slide. If you're an employee, the question is, does the attorney represent the company or the employee? And a lot of times the employees are confused about this issue. Just because there is a company attorney who sits down with you and says, we are working with the company to invest, because the company is being investigated by the FBI or the Inspector General's office, and you are going to be interviewed, and here are some things we want you to keep in mind when you're interviewed. Just because an attorney who represents the company tells you as an employee that information, that doesn't necessarily mean they represent you individually or your best interests. And that's why it's very important both for outside counsel or internal general counsel attorneys for the company to specifically tell the employee that they do not represent them, even though they're asking them questions as part of a larger investigation conducted by the government. If you are an employee and you're called in and asked questions about an ongoing government investigation into the company, the very first question you should ask those attorneys, do you represent me Or do you represent the company, or both? Because it's quite often and usually typical that they do not represent the individual, and the evidence they receive from the individual could be turned over to the government so that that individual will take responsibility or liability for the actions. Two other things I want to just raise with you when it comes to government investigations. Key TAM or False Claim Act cases. I've done several of these, and these are typically individuals who work for a company that is making false claims, usually false claims for payment to the government. So you're talking about healthcare. You're talking about people, companies committing Medicare or Medicaid fraud. You're talking about companies that have defense contracts and they are submitting claims for false payment. What does that mean? You know, in the context of a government contract, it could be that the company or employees are submitting inflated or false time records, getting paid for work they didn't do. Therefore, the Inspector General wants to go and investigate that claim. So for a key TAM case, what you have is what they call a relator or a whistleblower who notifies the government, usually through an attorney or a lawsuit that's filed under seal, of this kind of bad act or this kind of claim. The individual as a relator is protected from retaliation, but that doesn't mean it doesn't occur. The individual who is the relator who usually brings this claim, it is common for that individual to have participated in the very conduct that is at issue. And to be clear, you know, if you're an individual, that shouldn't prevent you from making the claim if you can make it in good faith. And you only make that claim through an attorney. If you're a company, then that's one of the defenses you're going to raise, which is, you know, the very whistleblower who's brought this to your attention either participated or maybe allegedly had access to or misappropriated trade secrets. So a key TAM or False Claim Act claim is a whistleblower claim for false payment submitted to the federal government. Typically, there are also state key TAM statutes. And finally, I just want to mention one other government investigation. That's under the National Defense Authorization Act of 2013. Basically, that means if you work for a company that has a federal contract and you are questioned by the FBI or the Inspector General about the investigation, and you give them evidence to help move their investigation forward, you cannot be fired. The company cannot subject you to an adverse employment action. Now, that too is an interesting statute because oftentimes the individuals who are interviewed by the Inspector General or the FBI under this statute are individuals who are being accused, again, of committing some kind of crime. But just because on the merits, the company may think they did something wrong, that doesn't give them the right to fire the employee for giving evidence or being interviewed by the FBI or the Inspector General. So as a company, you may say to yourself, hey, this individual is one of the bad actors. I know this. And by the way, I know they talked to the federal government, to the Inspector General's office, but you cannot fire them if they've given the Inspector General evidence to pursue their investigation. Those are just a couple basic things I want to throw out there, more on the federal side of government investigations. But let's get to what I really want to talk about today. And go ahead, Heather, go to the next slide. I call this the anatomy of an employment law dispute. And what I'm going to talk about are some basic facts and considerations about how you approach these kind of disputes. This is based on a case that I tried in federal court last May here in the Southern District of Texas. I represented the claimant or the plaintiff, Ms. Wooten, against a company called Invesco. The case itself had two central causes of action. Ms. Wooten asserted two claims against Invesco. One was Title VII, race discrimination under the Civil Rights Act, and two was retaliation under the Family Medical Leave Act. Go ahead and go to the next slide. Now, before we got to federal court, Michelle is absolutely correct. My client, for her Title VII race discrimination case, had to file her claim with the EEOC. And she did that. And I just want to talk not about the specifics, because I think Michelle covered those, but I want to talk about the general process. In general, and some people may disagree with me on this, but in general, the EEOC process tends to benefit the employer for several reasons. One is that it takes a long time, or it can take a long time. And that's not just because it's a bureaucratic process. During the pandemic, it was very difficult for the government to process the number of claims that they received. So in the Wooten case, Mr. Wooten filed her claim with the EEOC prior to me representing her. And that claim actually sat with the EEOC for over 250 days. Now, as a claimant in the process, or as a later plaintiff, you can understand how frustrating that can be, because you want to move your case forward, and you are, but only to a small extent with the EEOC. Ms. Wooten filed the charge, Invesco filed, and then it sat there. And eventually, because it sat there for so long, she had the right to request a finding of no determination and her right to sue letter. And so she was able to get that right to sue letter, and it was with that right to sue letter that triggered her right to go to court, in this case, federal court. Now, I want to mention, if you're an HR professional, and if you're an outside attorney, you probably know this. One of the reasons this is also an advantage to the employer is many individuals file their charges with the EEOC just by themselves. And you can do that. You don't need to hire an attorney. There are advantages to that. You don't incur personal attorney's fees. The disadvantage is usually the employer has sophisticated legal counsel, and they look at an individual who files a claim with the EEOC, and they understand that it's very unlikely that any claimant in that process is going to get an actual finding. So they will typically try to delay the process as much as possible. And when the right to sue letter is actually issued, they will just wait. If the claimant doesn't, and this happens quite a bit, if the claimant doesn't retain an attorney, nothing will happen. The clock will run on your right to file your claims under the EEOC. And at that point, you're out of luck. So in many respects, although it's an important process and you must exhaust this process before you file a federal lawsuit, my general feeling, and it is only my opinion, is that this process benefits the employer. Go to the next slide, please. I will tell you, that it's very rare in my experience to have trials when it comes to employment disputes, especially of the kind of magnitude that Ms. Wooten brought against Invesco. Ms. Wooten made, and by the way, I can talk about this because it's public record. What I'm telling you, the information I'm telling you is in the court's files. There is a transcript. The few documents that I'm going to show you actually were public exhibits. So there is no attorney-client privilege here at issue. And I mentioned that for two reasons. One, just I wanted to be able to relax and enjoy what you see. But two, every time there is a settlement, every time an individual settles their claim with a company, there is typically a settlement agreement where they receive a certain amount of money, but it's confidential. And that's good for the company because candidly, you do not want these kind of disputes out in the public because it encourages other people, perhaps, to bring claims. And I'd also say, ultimately, although it's good for the individual employee, it's kind of bad for employees as a whole. Because since this is confidential, it's very hard to get the kind of information specific to the company that you have a dispute with, or in general, about how much these claims are valued or worth, what the results are.
No, I was fixing this one. Hold on.
Okay. Can you hear me? Sorry, I heard.
Yes, go ahead. Go ahead. I'm sorry.
That's all right. I heard somebody else there for a while. So the fact that this went to trial is somewhat of a rarity. Ms. Wooten made $150,000 a year. She was an outstanding public relations officer. She had a title of director. She was in the Houston office of a company that's headquarters in Atlanta and then also had a major office in New York City. So she worked by herself in Houston to generate media coverage and interviews for Invesco employees. She, released on the facts, did an outstanding job. She arranged between 300 and 400 different interviews, which Invesco had never had before she started being employed there. She was considered by many of the people who did those interviews on her behalf, the Invesco employees or her internal business partners, to be excellent at what she did. However, she ended up having a dispute with her immediate supervisor and then her higher supervisors. So this dispute, which we'll go through in a little bit in detail, started when she was making $150,000 and it ended with a verdict where she received between $1.2 and $1.3 million. We're going to briefly touch on discovery, motion practice. We won't really talk about mediation, trial, post-trial, and appeal, and the kind of things that made this a unique case. So go ahead and go to the next slide. What is discovery? Discovery is simply getting the facts of your claim. And there are two sides. There's the claimant or plaintiff who has her own facts, and then there's the company who has its version of story, of the facts. And the way this plays out is by collecting written documents from both sides. That means emails, text messages, written evaluations, usually by the company, human resource records. There may also be company investigations. At some point, the employer or claimant is going to give notice of his or her claim of discrimination. And then there may also be tape and audio records. Go to the next slide, please. So let's talk about written documents, emails and texts and evaluations. This is a copy of a text message that was an exhibit in the case. And I like to start by asking everyone, what does the E in email stand for? Well, if you're an attorney, the E in email stands for evidence. Every email that is written regarding that employee in this time period is going to be something that is going to end up being produced, and it's going to be shown, and it's going to be public. Increasingly, text messages are also part of this written discovery process that are being recovered and used in employment law cases. As an HR professional, as a company, you need to institute some kind of electronic communication policy. One of which should be that there should be no personal communications through emails or text messages about your company. If that means the individuals need to have their own phone that's either paid for by the company or the company says you need to get one, that's a company phone only, then that's a policy that needs to be implemented for two reasons. One, so you can control the flow of information through emails and text messages. But two, because many of the emails that end up being key in these kind of disputes cross that line between what is a personal and professional email. Now this particular text message was a key piece of evidence in the case. And in it, my client, Ms. Wooten, was talking to her immediate supervisor. And Ms. Wooten was in New York having meetings with the company. She agreed to go have dinner with her immediate supervisor, a white woman. They got in the cab, and as they were driving there, Ms. Wooten told her, look, I feel like you treat me differently than the other white employees, that you treat me like an assistant, and I don't get the respect that I deserve. And her manager, as you can see in this text message, became extremely upset about it. And she actually got out of the car, got upset, had the taxi pull over, got out and said she wanted to go to dinner. And so what you have here is a text message where on the one hand, my client saying I was looking forward to a great dinner and you're yelling at me. No, actually that's the manager. And then my client is saying, no, that didn't happen. Now I can tell you my client did that. She testified she did that because she felt that her boss had a tendency to tell her one thing to her face and then put something else in writing. And so she spent a lot of time correcting the record in emails and text messages to make sure that it wasn't suggested that she was yelling at her or causing problems. And so you can see as this develops where, my client is saying, this did not happen. I'm talking about working in areas of opportunities. And then the supervisor says, I don't treat my team like assistants. And what happened was that little phrase, I don't treat my team like assistants, became a big issue in the case. The manager said, I was upset because Ms. Wooten suggested I treat them like assistants. Ms. Wooten said, no, What you actually were doing was you were treating me like a Black assistant. You were treating me like your assistant because I was Black and I had a different skin color. Now, obviously, my client was Miss Wooten. I believe her, but you can see that there are two different interpretations of what this text message can stand for. And as an individual, you need to collect this evidence. As a company, you need to be aware and institute policies that hold people accountable for what they say. This is a point that became a question of, did my client give notice of race discrimination in this email? And it was something that was taken to the jury. Let's go to the next slide. Other issues that come up is, and Michelle touched on this, every company has their company handbook or policies. Just because a company violates that does not mean they've created discrimination under a statute or a law. However, whether the company complied with its own handbook is often a key piece of evidence, both for a judge and a jury. Now, on the bottom right-hand side, you'll see there's an anti-discrimination policy in this handbook. That's very standard, and the company should have one, and companies will point to that and say, we could not have discriminated against our employee because we have an anti-discrimination policy. Be that as it may, if we turn to the next page, the key issues that usually come out are not whether they have a policy or not, because that's a private company policy. Whether they violate a statute under Title VII is separate and apart from their company policy. But the issues you have to be aware of, whether you're an employee, HR, or in-house counsel, are what is the complaint procedure? Does the company say it will conduct an investigation? And is there any kind of retaliation provision in the handbook? The complaint procedure here is key because it says that if an employee notifies the company of a complaint or a charge of discrimination, there will be an immediate investigation. And that investigation will, all you have to do is tell your supervisor, your business unit head, an HR rep, the head of human HR, all of those people count. And so one of the issues was, did Ms. Wooten tell her immediate supervisor she was being treated differently because of the color of her skin? Was that noticed, and did it trigger the company's obligation under its handbook to conduct an investigation? The other issue that came up in this case was the investigation itself. Here you have a handbook that has a policy of conducting an investigation. Every handbook should have that. The first issue was, did Invesco have an impartial person doing the investigation? Ms. Wooten objected to them because they had an HR professional who Ms. Wooten had talked to about her various claims over 6 months. And that HR person who she had spoken with was then appointed to do an investigation. She felt, Ms. Wooten felt, that that person couldn't be impartial. The company apparently agreed, and they removed that individual from being an investigator and put a second person who was in charge of HR in charge of the investigation. Now, here's what was bizarre. Although he initially said they conducted an investigation under oath in his deposition at trial, he changed his testimony and said no investigation was ever done. This is a major deal. And I bring it up to you for several reasons. One, their own, Invesco's own policy book requires that they conduct an investigation. The fact that they did not do it raised questions of their credibility and how seriously they took this woman's claims. And that was one of the issues that we put squarely in front of the jury. The second issue is that there were emails from the same HR gentleman in charge of the investigation telling Ms. Wooten that he had conducted one. And then later, under oath, he recanted and said he never did. That raised the question of whether he was being a truthful, credible witness. So I point these out to you because simply having policies in your handbook is not enough. How you conduct your investigation, how you conduct your complaint procedure, how you enforce your anti-discrimination policy is key. And if you do it right, then you can often nip in the bud many of these issues before they get to the EEOC complaint or to trial. Let's go to the next slide. I really think it's important to talk about honesty and candor in discovery. And when I say discovery, if you're not a lawyer, what I mean by that is in any dispute in a trial, the parties are going to exchange documents, and then witnesses are going to have to sit for what is called a deposition. And a deposition is when you sit in front of the lawyer and they ask you questions and you're under oath and you must tell the truth. If you are an HR professional, if you are in-house or outside attorney, one of the things that you should know is that typically the managers or supervisors who have discriminated, retaliated, or in their mind, justly fired somebody, do not want to be deposed. And depositions are a situation where you sit in a conference room and a lawyer like myself asks you questions for as long as 6 hours. It is not a conversation. It's one of the more uncomfortable things. And it's kind of something that lawyers know, but witnesses hate. But these depositions are very important. And as an attorney, if you're getting your witnesses ready to be deposed, it's important that you tell them very simply to tell the truth. Now, put more broadly, if you are in charge of defending a company or a plaintiff, the first thing you tell your client is, I trust you, but I have to verify your story. And you should. Because oftentimes the witnesses, whether it's the plaintiff or the defendants, oftentimes their story may be different than the documents. In other words, maybe a long time has passed. In this case, over 250 days had passed before we even started a trial. So people may recall something happening, but that's based on a false memory. More importantly, you need to make sure that your witnesses are telling the truth. And they may feel pressured to say something that maybe isn't 100% the truth because they want to support the company. So always trust but verify the facts and testimony of the plaintiff or your defense witnesses. The second thing I'd say is, how many times have we heard the story of the individual who's convicted of a cover-up and not the crime itself? It's very important that in any one of these disputes on both sides, you're going to have bad facts or things you cannot explain. Don't try to invent a story to cover up those bad facts. Simply embrace them. Tell the story as it happened. And there's a lot of power when you tell the truth to a jury, to a judge, or to anyone else. Number 3 is assume that you're being watched. Now, I say that because in this day and age, it's not just emails and text messages that tend to be the key evidence in one of these disputes, but more and more employees are tape recording their conversations with HR, with their supervisor, and anyone who's involved in an employee dispute. And that should be assumed because everyone now has a smartphone. The Apple, the iPhone is ubiquitous to culture, it's everywhere. And it's very easy to take your phone, put it in your pocket, turn it on, and as you speak to your HR rep, you're taping everything they say. In this case, again, before I became involved, but my client taped conversations with her employer. In the state of Texas, you're allowed to do that. In some states, you have to give notice to the party being taped, but not in the state of Texas. And increasingly, I think it's important for both employers and employees to know that the best evidence is usually the audio tape of a conversation that people either don't remember or they dispute or someone's not telling the truth about. I've mentioned about outside counsel and who do they represent? Do they represent the employer or the employee? My advice to companies, HR individuals, and outside counsel is if you are representing the company and you want to interview the employees, you need to make it clear that you do not represent them. If you give them advice about how to answer questions from a government investigator or what to do, and later on you try to say, well, wait, I only represent the company, you may have crossed that line. And by giving legal advice to the employee, you may have started to represent the employee. If there is then a dispute between the employee and the employer, you have created a conflict of interest that could get you removed from the case. Finally, I'll just say this, don't follow a script. There is very, very many very talented defense firms that tend to follow the same script. and you can see it. They will say an investigation was done in their filings, and that happened in this case when it was later found that there was no investigation. They'll make claims about what usually happens without really knowing if it happened in this particular case. If you make a claim, and it may seem small, but if you put in a motion for summary judgment, that your client conducted an investigation and found no discrimination, and then later the judge finds out there was no investigation, the judge may lose faith in your story and whether you're telling the truth. And once you lose that credibility, you can't get it back. Let's go to the next slide. So this is simply an order that came out in the Wooten case. And I know it's a little bit hard to read. And Heather, if you can pull up the text a little more, please do. But if you can't, I'll just go ahead and read it. So if you take a look at the first page, Heather, under Roman 2, if you can pull it. I don't know if you can. This is a court order from a federal district judge on a motion for sanctions, where he found that the witness in a deposition had committed perjury. And the reason why was because the witness initially was answering questions, and then as he's being videotaped, he got upset and he left with his lawyer. They came back, and all of a sudden, every answer that he gave was, I don't recall, I don't recall, I don't recall. This became more problematic because there were tape recordings of the conversations that he was being asked about. And so it was very clear he had suggested to, Ms. Wooten that she settle her case and withdraw her EOC claim and do several other things that he then denied and said he couldn't recall. When this was submitted to the court became upset and granted a sanctions order, saying that it was very clear that he was remembering one thing and saying another. For instance, and I'll just read this from the order, the judge found that the witness denied unequivocally having offered to settle the plaintiff's claims, yet other evidence shows that he unequivocally did make an offer. Both statements cannot be true. So later in this, under Roman 3, the court takes the further step and says not only was his conduct sanctionable, but he was assisted by his attorneys in making these mistakes. So that goes to the overall theme. Again, sometimes it's the cover-up, not the crime. You should assume that you're being watched, that things are being recorded. And if they're presented to you, you really can't deny them. And finally, you really just need to be honest in these cases. Nothing's always, it's not black and white. There are going to be facts on both sides. And if you simply don't embrace them and tell the truth about what occurred, you could end up with an order like we received in this case. Let's go to the next slide. So I talked broadly about discovery. And if you're an HR professional, one of the things you have to keep in mind is that when you're in a process of attempting to terminate an employee, the documents and the stories often evolve. And if that happens, then the company could be in peril. And what do I mean by that? Usually the reason someone is fired, whether it's right or wrong, legal or illegal, is very clear from both points of view. Ms. Wooten argued very, very passionately and consistently the same story. I was fired because I was Black. I was retaliated against because I made a claim under Title VII. I was retaliated against because I made a claim under the Family Medical Leave Act. Her story didn't change. But the company documents did change over time. And although the company tried to say, well, this is our story, she simply didn't perform well, the evidence from the documents showed that over time, they retaliated against her more and more and more. This document is simply the end of the year overall performance review, and it's difficult to see, but there's a paragraph there where the company says, we're going to put you on a performance improvement plan because of 2 reasons. Now, my client got very upset because she actually thought going into this review that she was going to get a promotion because she felt she had done an outstanding job. What she didn't really take into account was the disagreement that she had had with her immediate supervisor in that taxi in New York. When she got this end of the year review where they're saying, you're going on a performance improvement plan, and that is a common procedure done by companies that says if your performance doesn't improve, you could be terminated. She looked at that and she was very upset because the metrics that she had achieved in terms of interviews and quality of coverage for Invesco were outstanding. Go to the next page, please. This performance, end of the year performance evaluation was given to her in the middle of January. Then at the end of January on the 22nd, Invesco gave this performance improvement plan, which detailed what she supposedly needed to do to keep her job. The only thing I'll point out is this. The first document had two things she had to improve on. This document, and again, I apologize for the size of the print, but if you look at the second page, you'll see 4 bullet points. So in the space from her receiving her first evaluation, end of the year evaluation, which she contested at the time, to 10 days later, it's gone from 2 to 4 issues that she needs to address if she wants to keep her job. Go to the next slide, please. The performance improvement plan was in January. On February 20th, she was called into a meeting and told that she was not performing and improving her performance. And so on February 20th, I'm sorry, this is her written notice that she felt like she was being discriminated against. Now, she had told her HR rep that she felt she was being discriminated against, but she never put anything in writing until this moment. And on this same day, she took family medical leave under the FMLA. So they're on written notice, and frankly, verbal notice is just as good. But on this day, she goes into the Family Medical Leave Act, saying that the stress of this process is too much and she needs to seek medical attention. And that was confirmed by her doctor. And then go to the next page, please. When she comes back in May of 2010, the company has now created a list of additional bullet points that they say she needs to improve under if she wants to keep her job. There's now 12. If you count those individual bullet points, there's now 12. And so this is the point I want to get across to HR professionals, attorneys, and even individuals who feel like they're being retaliated against for asserting their rights under the FMLA or Title VII. Documents will often show if the story stays the same or if the company changes their position. In this case, the company in the performance review had 2 issues with her. Under the PIP, they had 4. She then goes under the FMLA for 2 months. She comes out not having worked, and they now have 12 issues. And that was a very important point because the documents evolved and the company tried to make their claims stronger and stronger and stronger. And that showed that they were actually retaliating against my client because she had taken time out and she'd made these claims. That was our argument to the jury. Some of the things, the other issue is this. My client always responded to these letters in detail. And one of her complaints was, I see that these are the things you're saying, but they're so general. What kind of metric, what benchmark do I need to achieve to get off this PIP to satisfy the company? And the company would never give her actual benchmarks. And that was one of the complaints and one of the arguments was that candidly, they never intended to take her off the PIP. They're simply using the PIP and this process, an intra-company disciplinary process, to justify their decision to terminate her. And they'd already decided they're just playing it out. That was her argument. Now, again, it's tough to see some of these bullet points, but I'll just read 2 bullet points to you. And I'm reading these to show you how general some of these claims were that the company was making about her alleged poor performance. Bullet point 2 says, you will execute your role in the context of the greater Invesco when it comes to creating and implementing media relations strategies. What does that mean? And she asked very clearly to have that defined and given a metric so that she could satisfy that claim, but they wouldn't do it. So what is the greater Invesco? How do you satisfy that kind of requirement? The second to the last bullet point is similar. You will be flexible with business partners and recognize the culture in which we operate. Well, what does it mean to recognize the culture? How do you address that? What kind of metric did she need to achieve or benchmark to satisfy that concern and have it removed so she could continue working. Now, the other bullet points here are also much more specific. But candidly, they're a problem for the company because coming out of her family medical leave, they instituted new requirements. They said she had to be at her desk from 8 to 5, and they knew that she then couldn't pick up her son from high school. That was an issue. One of the conditions of her job was that she'd be able to leave and pick him up, in part because she worked starting at 5 a.m. in the morning and all through the afternoon and evening, because many of her internal business clients were international. They required her to do things like, before she sent an email, she had to have it approved. She had to give her manager daily updates. She had to be a team player, whatever that meant. And these things like she must be at her desk during business hours. Well, if you're a media relations professional, half or more of her time is
Hello, Mr. Eric?
they
Did
could
we lose him?
fire her. So I just
I think we lost you for a second there. It froze.
Oh, I'm sorry. Can you hear me again?
Yes,
Yes.
you're back.
Okay. So the conclusion that I want you to take from this document is that the company, with these specific changes in what she had to do in restricting her job, they had set her up to fail. They made it impossible for her to perform at the high level because she couldn't leave and talk to media outlets. And this was key evidence. Not only did the requirements, did the things she needed to fix go from 2 to 4 to 12, but many of these things simply couldn't be satisfied. They were either too general or they worked to keep her from doing her job. That was an adverse employment action. They were restricting her from doing her job as she had done before she went on leave. Therefore, it was retaliation because they knew that she would fail. That was her argument. On the broader side of this, I just want to leave you with this. If you are a company person, these documents, which changed over time, they show a change in position over time. And that indicated that the company wasn't serious about giving her benchmarks. They never gave her specific things she could do. Instead, they kept increasing the number of things that she had to do, and that showed retaliation. All right, let's go to the next slide. So I'll leave you, on this topic, I'll leave you with a couple thoughts. Depositions matter. What is said in a deposition matters. You would be surprised some of the things that you learn in depositions. Even though it's an employment law case, it's important to be prepared to give a good deposition. I won't go into this much, but there are also people called expert witnesses. In this case, Invesco had an expert witness, and he was actually disqualified at trial under cross-examination. One of the problems with, employment law disputes and claims, in terms of the law, you have professional firms who do a very good job, like Michelle's firm. And then, in general, companies don't want to pay legal fees, which I understand, but they don't want to pay a lot of money or invest a lot in defending these types of claims. And so, the experts that they sometimes retain are really, not the best. But there's a reason for that. It can be cost prohibitive. And so there's a balancing there. And I'll just simply say this: if you're going to have someone come in and testify, on behalf of the plaintiff to your damages, make sure you get someone who's experienced and is qualified and very good at testifying about how much money you lost and why you're entitled to what you're entitled to. On the flip side, you need good defense experts, and they can be key because they will sit in a jury box at trial and talk to the jury. And because they're not someone who's involved in the head-to-head dispute, a lot of times they have a veneer of authority because they're experts. And when that happens, they can be very, very powerful advocates for whatever side they're testifying for. And then there's the verdict. Let's talk about a verdict. Let's go to the next slide, please. So this is part of the verdict form. And you would be surprised, the trial itself went for 6 days. And I don't know the exact number of witnesses. I would like to say there was 8 to 12 when you combine it for both sides. It all comes down to these basic, what they call interrogatories, which are just questions that are being asked to the jury. And in this particular case, the jury came back, and when they were asked, would Miss Wooten, was she terminated because of her race, because she's Black? The jury said no. And they found no discrimination under Title VII. And you'll see that also on interrogatory number 2. But here, they say, no, she was not discriminated or against because of the color of her skin. But they say, yes, she was discriminated against under the Family Medical Leave Act. So to a certain extent, it's a split verdict. But even though it was a split verdict, it comes out in the plaintiff's favor. Let's go to the next page. On 2 and 3, they basically do the same thing. They say under the FMLA, she was discriminated against, but she was not discriminated against under Title VII. On the right side, you'll see her actual wages that she lost, according to the jury, were $380,000. And if you go to the next page, you'll see on the bottom there for punitive damages, she was granted $618,000. If you add up the two figures, it's an even $1 million. Let's go to the next slide. So if the jury gave a $1 million verdict, how did she end up with 1.3 million? Well, I'll just say this. There's an old saying, the opera ain't over until the soprano sings. This trial ended in May of 2021. The verdict was signed and issued in December. I mean, sorry, the verdict came out at the end of the trial, but the actual judgment, which is the judge signing off on everything that is entitled, that the plaintiff is entitled to, was not signed until December of that same year. Why so long? After a trial, there's all kinds of motion practice. We submitted our attorney's fees. We asked for what's called liquidated damages. In these employment cases, under the FMLA, a plaintiff is entitled to double the actual salary or pay that they lost. So the $380,000 that she was determined she lost in terms of salary, that was doubled. There's pre-judgment and post-judgment interest on that amount. And then there were attorney's fees, which were submitted in $250,000 in attorney's fees, which is quite a bit actually in a Texas employment law case. After all that, there was extensive post-trial briefing by lawyers. That's lawyers writing arguments and filing them with the court over attorney's fees, over whether there should be a new trial, and various other things. So, you know, at the end of the day, there's a good 6 months that goes on after the verdict before the trial court says, here's your judgment. Now, in this case, Invesco did not appeal it. If they had appealed it, then, you know, you'd be looking at anywhere from 9 months to a year to maybe longer for the appellate court to issue its appeal or its ruling as to whether the judgment and the verdict stand or whether it gets overturned and goes back down for another trial. In that respect, appeal is a weapon because it's a threat, not only to lose the money that you've gotten in the verdict or the judgment, but also the length of time. And, you know, again, the process, including the appellate process, is really an advantage for the employer because the individual has been fired. They may or may not have been able to get another job. And because of that, the longer you wait, the harder it is, especially in the pandemic, for them to survive. So my overall thoughts on this particular process and what occurred is this. It's very, very rare to see employment law trial cases like this go to a jury when it involves over $1 million. And although I really have to tip my hat to my client who was adamant that she get her day in court, it's still very difficult when the amount of time involved in a legal process can go on for a year, 2, or longer. So what do you need to think about, whether you're the employer or the employee, when it comes to these disputes? Number one, if you're, the employer, it's really in your best interest to go through the EEOC process and then see if the employee gets an attorney. For an employee, although I realize the cost of an attorney can be prohibitive, there are contingent fee contracts. And I really feel that if you don't get the right attorney, or if you try to do it yourself pro se, you're not going to get the result ultimately that you want. And that result is two things. One, under our process, and it may be imperfect, damages are what you receive if you prevail. You get paid in money. The second thing that I think is very important, and that was very, very important to my client in this case, is she wanted a jury verdict showing that Invesco had done wrong. She received that under the FMLA. I'm not surprised necessarily that there was not a finding of discrimination. My personal view, and I respect the jury process, my personal view is that the jury really made a compromise, that there must have been a split of opinion in that jury room, and that ultimately, and again, I'm speculating, ultimately, I think that what they said is, if you agree that there was no discrimination, we'll agree that they violated and retaliated against the plaintiff under the FMLA. And as you can tell, a $1 million verdict is symbolic. And so I think that there was a compromise in the jury room, and then they were going for a symbolic number, which candidly for discrimination under the FMLA is a large number, but they wanted to send a message. Now, the last thing I'll say, and then we can open the talk to questions for both Michelle and myself. I think one of the increasingly lost arts are people who are willing to take their claims all the way. And I think it's very, very important that you seriously consider going to trial. Two things happen when you have the mindset that you're going to take your dispute through EEOC all the way through a trial. Number one, your attorney and you approach it differently. You're much more aggressive and focused. And by doing that and attacking these cases aggressively, you put the defense on their heels and you force them to take it seriously. Many times, if you're not aggressive, the company, quite smartly and rightly so, simply allows the process to play out, takes their time, and then eventually says, well, we will settle for a little bit of money, but you won't get the outcome that you want. And then the second thing is exactly that. The lost art in American law, whether it's employment law or law in general, is the jury and going to trial and having an actual jury render a verdict. Fewer and fewer cases are taken to a verdict in front of a jury. And I think that's unfortunate. Although I believe in mediation, and I believe people should work constructively to compromise, I still firmly believe that the jury itself is the best place to go to determine the truth. And such things as truth, although it may sound a little bit corny in this day and age, the truth matters when you're trying to establish whether or not you discriminate against. The truth matters not just for you, but for other people who are in a similar situation. Whether you're the plaintiff who wants to establish that this occurred to you, or the company who wants to prove that it never did, getting to an actual verdict where a jury makes that decision, I think is one of the most important things that can be done in this day and age. And with that, I'll pass it and open it up for questions.
Oh my God, brilliant. You two are amazing. We really enjoyed it. I was just writing down and I kept talking to Nia. Oh my God, that's something new we learned. So guys, thank you so much. And Nia, there are some questions.
Yeah, there's only a couple that I've seen here. It says, how does filing a claim or lawsuit affect your future employment? What is the affected company allowed to say and not say about you leaving?
Eric, you want to take that or you want me to take that?
You take it and I'll follow up.
Okay, so that's a great question. That's one that I probably get every time someone comes into our office. First of all, it's important to know that the EEOC, the TWC process is confidential to a point. In order to get any of those documents from the EEOC, you must file a Freedom of Information Act request. And you can only get those documents if they are, if the EEOC and their FOIA department approves. So for instance, I can get EEOC documents because it's related to a lawsuit. And so you have to, those documents are confidential unless you have approval to get those. So as far as other employers finding out about you filing a charge, unless you tell them, there's no way for them to find out through the EEOC. Now, there is a way for them to find out if you file a lawsuit, because those are public records. And if you file a lawsuit against your employer, then your potential employer could look that up and find that out. And if they do decide not to hire you, there's of course no law against that. So it really all depends on where you are in the process. But there's no law that says that if you have filed them against your employer and your potential employer finds out about it, if they decide not to hire you, that's not illegal. It's just highly unlikely, honestly, because as an employer representative, we don't go searching lawsuits to see if you sued your last employer. I don't think that's very common, and I don't really recommend it, because why waste the resources when typically you can ask, or hopefully you don't have to, but they're not going to find it at the EEOC.
I think they were asking what was the previous, is the previous employer even allowed to even mention it? Can they say something? So if I were to call you for an employment verification or something for Myra, I'm thinking about hiring Myra, but Myra sued you, and there was a big hoopla or whatever, and then eventually terminated or left or whatever reason. So if I were to call you and say, I'm just looking for reference or something about this previous employee, what are you allowed to say?
Well, I mean, you can say anything you want as long as it's not a lie. If it's a lie, then that's a defamation claim. That's going to be, that's when you're going to get into defamation. I think most employers are very cognizant of that. Most employers will just give what I call your name, rank, and serial number, give your name, give your dates of employment, give your title. If they are asked, it's not illegal for them to say that about you. As long as they're not lying and it's some kind of a defamation claim, it's not illegal. It's highly unlikely, though. I've never in my 17 years heard of that happening. I don't know. Eric, have you?
I haven't heard of it happening. It is a little, look, if you file it and the claim that you're talking about ends up settling, then it's confidential and the employer cannot tell the other side. So now if you file a claim and say it's for $50,000 or $60,000 and it's denied, I agree with Michelle. It's very rare that that's going to get out in the public. The higher up you go, however, the more attention you're going to grab. So Ms. Wooten, of course, her lawsuit was carried on the national legal indices. It was a little bit of news. It wasn't amazing, but it's out there. And she pretty much resigned herself to the fact that she didn't expect a company, a financial institution of that size, to ever really want to hire her again. That may be true, it may not be true, but her verdict is out there. And I'll tell you, I get people calling me to take on claims under the FMLA because it's public. The other issue would be whistleblowers. And, again, I have represented certain doctors in whistleblower actions under the False Claim Act. And they, because of the level of professionality and that they're at, they are very concerned that eventually the seal is lifted and their identity will be revealed. And how is that going to affect another hospital or really company being operated by an outside third-party vendor? Will he get fired? Will he still be able to find employment? But that's really for a high-level individual who is involved in million or multi-million dollar cases. The general smaller claim is still extremely important to everyone because it's your claim. But I think that it's less likely that people are going to want to say bad things about you or find out or ask about it. I will say one thing I forgot to say, or if I'm repeating myself, I'm sorry. this is kind of a new part of my practice, you know, as I've said, in the last 5 years or so. And it's really great law to practice, whether you're representing a small company or an individual. And that's because, you know, we don't really think about it, but people's jobs are an anchor of their identity. I mean, it really matters. And when they feel like they've been wronged under a statute for whatever reason, you know, it's deeply personal. So at least I will tell you this, that under this kind of law, it's very difficult, but extremely satisfying to represent people who have these claims, or to represent even companies that feel like they're being wrongly targeted if they're good, legitimate companies trying to do the right thing. So, you know, on that level, it's a slightly different, I know it's a little off topic, but I will tell you, I'm sure Michelle feels the same way. It's really a great practice of law because you get to represent wonderful people. And these claims are very important. And so when you come and ask us these questions about your claim, it's something I take very seriously. And it doesn't matter if you're looking at $50,000 or more, you know, your job is your identity. And that's why these claims are special, even when they're not multi-million-dollar claims.
And you know what? I love when you said that, because a lot of people don't realize that 99% of most of the employees love what they do, are proud of what they do, and basically their job says who they are. So when you're going through that process, you're taking it personal, because my job is me, who I am. So you're talking about me as an employee that is not doing what I'm supposed to do. And that just stresses, changes the whole atmosphere of the process. So understand, love it. Thank you.
I was under the impression that there were certain things that an employer could not say, or a potential employer could not ask of a previous employer. So they basically can tell them, if I ask you anything I wanted to know about Myra, you could answer it with, as long as it's not a lie. You can say and ask anything you want, right?
Right. Yes. I mean,
Oh, wow.
they would, obviously, they're not going to want to ask you or base your, you know, base your hiring on. They can't say, well, what is your race? What is your sexual orientation?
Right.
What is your gender? You know, I mean, obviously that's going to be discriminatory, and they can't ask something like that. There are some HIPAA rules that you don't want to get into violating, asking people about disabilities. It kind of skirts the edge there, medical issues, things like that. But again, as long as they're not lying, there's no law that oversees what you can and cannot ask a reference. You know, but a lot of there's case law out there that will find defamation claims if the employer did lie about an ex-employee, a former employee, and that's where they have to be really careful. And which is why most employers are very, very careful, because they don't want a defamation claim, because they don't want them to bring a claim of or you know, discrimination or something like that. I think most employers are pretty savvy, and they're not going to ask anything like that. You know, some may not be, but I think that's not necessarily the rule.
As a practical matter, I'll just piggyback quickly on there. You know, if you're an employee, it's important to also have really good relations with other people at the company, because right. I've seen this happen where, of course, someone is wrongly terminated or they leave, and no, they don't want to direct their next employer to HR at the company, but they will say, oh, my supervisor or a person in management, I worked with them, they've agreed to be my reference. You can call this person. And that person, there are people usually in your company who have a different opinion and think you're the best. And then there are people who think, oh, she's horrible, you know, or he's horrible. So as a practical matter, have that person who's willing, you know, I can tell you that there was a very high level person in Invesco who felt that my client was treated terribly. And he said, I agree to be your reference. I won't speak for the company, but I will tell them when I was there, you were absolutely outstanding. And so as a practical matter, try to have that lined up. But you know, Michelle's right. The other thing is, you know, again, unless someone's taping the phone call, it's very difficult to prove that a former employer said something bad about you. You know, are you expecting a new prospective employer to say, oh, I didn't like what they said, let me go tell this person and I'm not going to hire them? I mean, it just doesn't happen.
Mhm.
So, you know, it is a little bit difficult, you know, it's not always an easy answer. But at the same time, when you've been wronged, you don't always have the option of leaving on good terms if you want to protect your rights.
There weren't any other questions in the chat, but I'd like to open it up. If anyone else has any questions, that they feel free to unmute yourselves and ask your questions directly. But in the meantime, I did have my own.
Sure.
What happens, and I know you said that Texas is basically an at-will state, so somebody can let you go for any reason. In the scenario of your client, Eric, when she comes back after, you know, filing the claim or whatever initially, and then having to go on family medical leave, and then she comes back, what's the recourse if they just decided they were going to let her go, where they could say, we eliminated your position, and, you know, or we just decided, you know, this probably isn't a good fit for you, or something, you know, how do you prove that that was retaliation versus we really are downsizing, or we really did eliminate your position, or I just want you gone? You know, what do you do?
Well, and then that's kind of where I guess the rubber hits the road. We are an at-will state, but once someone gives you notice of a claim of racial discrimination or any claim under Title VII or a claim under the FMLA, if you fire them after the fact, it's a fact question for the jury. And if the jury finds, yes, it's at will, but they didn't fire you because of bad performance, they fired you because you complained under one of these statutes, which protects you as a person, a jury can find that that is what happened. And therefore, the fact that you're at will doesn't matter. Now, at trial, in my particular trial, yes, Invesco, the company, was saying repeatedly, we are an at-will company. We could let our Miss Wooten go at any time. We could fire her whenever we wanted. The problem was they felt so concerned about it that they fabricated, in my opinion, fabricated the story, increased all these, you know, went from 2 to 4 to 12 reasons why she wasn't doing her job. And when you hand that to the jury, they look at it and they say, well, we don't believe you. We think you're just trying to create more pretexts to terminate this person because of the color of their skin or because they took FMLA. But, you know, do I think that companies, as a general rule, if they, you know, if they want to look at someone's performance and say you're not performing, we think there could be a problem in the future, we're going to fire you and fire them now. That's what I would recommend you do. If you feel like someone's underperforming, don't wait. Try to correct it, but if it's not going to work, you can fire them for at will. The minute they turn around and say, "Well, I think you're treating me this way because of my gender," there's a fact question. And that question has to be answered by the EEOC or by a jury.
So for an employee, that's something that they should start documenting immediately.
Exactly. And, you know, look, as I mentioned, you know, document it in writing, push back when you can, and everyone should assume that you're being taped in these conversations. Because in our case, even though we didn't have the most damning recordings, the fact that they tried to deny what they said on these recordings really hurt them with the judge, and they got a sanctions order. I mean, if you feel like you're being threatened based on the color of your skin, your gender, or anything under Title IX or FMLA or these other statutes, you know, if I'm your attorney, I'm probably, and you're in Texas, I'm probably going to recommend that, yeah, you tape that conversation with the person who's talking about possibly firing you. Now, I need to reassert here, not every state is like Texas. In Texas, one party to a conversation can tape it. So we're having a two-person conversation. I can run that tape recorder or that smartphone without telling you. I believe in California, I could be wrong there, but other states, it has to be both people consent. You know, so in this day and age, whether you're the employee trying to prove your case or whether you're the company going through this process and looking to terminate or discipline somebody, everyone should assume the conversation's being taped.
All
Yeah,
right.
that's a great point. And I just want to follow up to say, no matter which side you're on, employer or employee, document, always, because that is going to could be used as evidence.
And that is so important, because a lot of people, if you feel it, if you're at work and you feel it, that something's going on, I'm not saying it is, but you should write it down anyway and document it, just in case. It doesn't mean that it's happening, because, you know, a lot of times I'm I'm a second guesser type of person. If you tell me something and I feel funky, I'm gonna kind of look and, double look at it. But, and a lot of times it's not happening. It's just me being just Myra. Like I tell Nia, this is just Myra. But if you feel it, you touch it, you should write it down and keep it updated.
One more question here that I have, and I want to,
Go.
based on the things that I've heard people talk about and what I've heard people say, if you have an employee that either has property, has material, has something of the company or organization, and then they leave, but they have destroyed the property, they didn't return it, they didn't whatever, and they're due a final paycheck. What happens in that scenario? Because I've heard some employers say, well, we're going to withhold your final check until you return the equipment, or we're going to deduct what you've broken or damaged or didn't return from the final check. What's the employer supposed to do in those situations?
Okay, so there's something called the Texas Payday Law, and that requires an employer to pay their employee their final paycheck within 6 days of when they either, 6 days within if they've been terminated, or by the next pay period if they have been if they've resigned. So within that law, what it says is if they are, for instance, a lot of times it comes up that a person has been given uniforms, and those were given to them, but there might be a policy that says these are going to be deducted from your final pay if you don't, if you don't give 2 weeks notice or whatever like that. So it's although it's a little bit tricky, you can deduct those things from their final pay. Now, if they file unemployment, the TWC might question all of those, but those things can be deducted. I wouldn't do it without just making sure that the things that you're deducting fall within that act. So I would ask an attorney just to make sure that it's okay to do that. Obviously, if they have destroyed property or something like that, that could even be a criminal issue. But you can deduct those things, but you have to make sure that you follow the parameters, and just make sure that you get some legal advice. And you all can call me, just give me a call, and I'll tell you. I'll look it up because I don't have it memorized. And that was the final thing I did want. I know Eric and I wanted to give our contact information, and I'll just put mine up real quick. Yeah, you can always just email me a quick question. I'm always willing to help or give free legal advice if it's not going to take me too long. So just give me a call, and I know Eric probably wants to share his information too. But
well, I wasn't as prepared as you, but I'll just tell you, if you want to find me, just go to curtis.com. www.curtis.com. I'm in the Houston office. It's Eric Cassidy, Butch Cassidy, Hopalong, whatever you want to remember me. And I'd be more than happy to talk to anyone who has a potential claim or just a question.
And I do have one question, because COVID, we're still going through COVID, and some people were lost their jobs or did get COVID and are still having issues because of COVID. Were there any specific new laws, new regulations to protect anyone with COVID or any of the symptoms or the ongoing symptoms? I know that would be FMLA, but.
So the interesting thing about COVID is that it hasn't been decided whether or not it's an actual disability, because it's not long term, and it could be short term, it could be long term. So it doesn't. It's a strange little illness that doesn't actually qualify as a disability, but it doesn't not qualify as a disability. So it depends on what the symptoms are, whether they affect any major life activities. It depends on how long the symptoms last, and things like that. So we're going to start seeing lawsuits probably within the next year or two. I'm expecting a lot of disability claims. We obviously had a lot of workers' compensation claims that came out of it. We had a lot of unemployment claims, and those right now that everybody's finally going back to work or trying to go back to work, if they're refused and their company says, no, you can't come back because you have COVID, I would probably go ahead and file a disability claim because that law is not settled yet. So that's a really interesting area that's going to be, I think, probably a big part of my practice coming up the next few years. The aftermath.
It's going to be interesting. I just,
is.
Because we work with so many employees here with the city of Houston, and they're public service employees that you deal with everyone.
Oh, sure.
And I think it's going to be really interesting coming up what's going to happen, the outcome of COVID.
Yeah, we're going to see a lot of different results too. So it's we're watching it closely for sure.
Thank you.
Okay. All right. I believe that is it. Eric and I, or we both kind of put it in at the same time, put your website in the chat. But I'll be happy to include your guys' website or your email address if you want to send me the contact information, and I can send it along with the recording for everyone to go back and to review. On behalf of A Month of Service, thank you guys very, very much for taking the time out this afternoon. There was a lot of information that you all covered within that 2-hour time period, and that time went by pretty fast there. So what do we have coming up?
Yeah, before
Yes.
we go on, we want to make sure that you guys come back, because there's so much information that you all have given us, but I know there's much more, and you both have done such a wonderful job. I know when Nia and I go back this evening and we start talking, we're going to say, wait a minute, okay, they said this, wait a minute, I love this, I have this question, so we'd love to invite you both back, and we want to welcome you. Thank you so much.
Well, thank you so much. It was wonderful to be here, and employment law touches every aspect of our life. So there's a lot to talk about. So I'd welcome coming back. Thank you both.
And a lot of misconceptions where people think or assume that wrongful termination is actually a thing, since there is no such thing. So I was wrongfully terminated. No, you weren't. So that's a whole nother subject. But thank you guys very much. For our participants, we certainly invite you guys to come back to join another month of service presentation. This week we have tomorrow. Property tax protest deadlines are coming up on the 16th. So tomorrow we are having Harris County Appraisal District and Tax Assessors Collector's Office to talk about property tax valuations and the filing protest deadlines, filing for exemptions, or for those people that are still experiencing financial hardship, payment arrangements that you can make and other payment options that are available to all of you. And then on Thursday, we have Earl Carl Institute will be presenting about our inherited property and clearing title and other probate concerns. We know that there are a lot of folks still that cannot qualify for assistance due to the fact that they don't have their homes in their names. They're still living in properties that belong to parents or grandparents because they passed without wills. So they would need to know how is it that they actually can get that property registered to the people that it actually is supposed to belong to, so that they can qualify for those services. So you guys may want to join us back to that as well. So again, thank you guys very much for your time this afternoon. Really appreciate it. Wonderful information. We will be emailing the link out to everybody to go back and view the presentation again. Ask that you pay it forward and share it with someone else that may find this information to be beneficial. You can also follow us on Amos Houston TX, where the live session is also being posted on there as well. So thank you guys very much. We hope you all have a wonderful remainder of your afternoon, and continue to stay safe and take care of yourselves.
Thanks, everyone.
Thanks.
Right. Have a good one.
Bye-bye.